Welcome to Silberman Law Firm's Weekly Docket, episode 46, where we talk legal news and practical law. Today is November 27th, 2024, and I'm Phil Silberman, owner of the firm and your host. And I'm joined by Austin Black, who is my co-host. How are you doing today, Mr. Black?
I am thankful today.
It's the Wednesday before Thanksgiving. Tomorrow is Thanksgiving. This is our Thanksgiving show.
Yes. Our Thanksgiving show. I'm so thankful for all of our listeners, but more so than our listeners, I'm thankful for Phil this Thanksgiving.
It's called buttering up the boss. But... Okay, we're doing something a little bit different this show. We're calling this inbox potluck, okay? And what I did is we have this main firm inbox, and I just went right down whatever we get. We're not disclosing any confidential information or any specific names or any fact patterns that would allow anybody to identify someone specifically. But we're just going down the list in the inbox. We're telling people what we get, what lawyers get in our inbox, and we're just talking about it. All right, so let's go ahead and get it started, Austin. What's the first thing that showed up in our inbox?
Yeah, so the first thing that showed up in our inbox in this shotgun inbox that we're doing is, can I deed a property back after acceleration to avoid lender enforcing due on sale? Okay. So just to contextualize that, this person does not mean like after they speed up in their car, can they deed a property back? No, that's not what's happening. They mean acceleration of their mortgage, right? So they continually miss the mortgage payment, and then the lender sends them a notice of default with intent to accelerate the note, like where the entire note is due. That's what they're talking about. So.
Yeah. And when you get it, when the lender sends an acceleration over, what they're doing is normally that installment contract. So if you pay a mortgage every month, you pay X dollars, you're paying back principal and interest. When the lender accelerates, which is necessary when you're doing a foreclosure because you want to foreclose on the property and have your whole note be part of that foreclosure.
Yeah.
Otherwise, you just be foreclosing on a balance, on a 1 month balance due. Nobody wants to do that. So you accelerate, and then you send this notice over to the borrower saying, hey, you've accelerated. The borrower will typically panic and say, oh my goodness, what happened? In this case, it looks like the bank is trying to enforce a due on sale clause, which is a clause in the deed of trust that says, should you transfer the property, the lender may call the note due. That's permissive. Usually not mandatory. In this case, it looks like the lender is doing that. By the way, this is very rare. I almost never see this. Most banks do not call performing loans due. Although we are finally in a higher interest rate environment. So if a bank made a loan 5 years ago at 4% or 3% and mortgage rates are now at 7%, the bank might have some incentive to call that note due so they can lend the money back out at the higher rate. This person wants to know, the bank's accelerated. It's like letting a cat out of the bag. The bank's accelerated and the borrower say, oh, no, I don't want that to happen. And it looks like the borrower deeded the property out of their name, probably into an LLC for asset protection purposes. That's normally what happens. And then the bank saying, hey, you can't do that under my due on sale clause. And the borrower is panicking, saying, can I fix this? Now, sometimes in these deeds of trust, Austin, it can be fixed, right? There'll be like a 30-day notice of cure period. So you have to give the borrower a 30-day period to cure.
Yeah. I don't see this very often anymore, but yeah. It can
so
be.
Typically, the cure period is going to exclude the due on sale. It's going to be like, okay, you can cure some money owed, but once you deed it back, just putting the property back into, your personal name that you borrowed the money on, that typically just doesn't fix it, because once you let this cat out of the bag, once you accelerate, the bank can't really get that back without doing some type of document and officially rescinding the acceleration. That's usually what needs to be done.
It's rare for a mortgage company to be like trolling through the property records, or obviously they're probably paying someone else to do it, to see if their properties that they have notes on have been transferred. But in higher interest situations, that would be the most common.
Yeah, almost unheard of. So you could deed the property back to your personal name, send it to your lender. Hopefully the lender will stop the foreclosure. That may or may not happen. If it's a sophisticated lender, what they should do is do some type of rescission of the acceleration so they preserve their rights. If they don't do that, then if the loan later goes in default and it's been after 4 years, because that's the statute of limitations on foreclosing on a note, the lender may have prejudiced themselves and not be able to foreclose after 4 years if they didn't try to put that cat in the bag, if they didn't try to, undo that acceleration.
Yeah, that's true.
All right, what's our next question?
Next question is, these people purchased a home that already had a patio. The new management company told her that she bought a problem, but they didn't really care. They said she got cited for a missing picket Okay, it just seems like there's a lot of fighting over HOA stuff, basically.
Yeah, and I think
it's a bit jumbled. Yeah.
So it's for our listeners out there, it's not unusual for us to get jumbled, incoherent requests, and this is, again, inbox potluck. She buys a house, the patio was never approved. And then also, I guess she had a fence and it was missing a picket, like one of the
Something
pickets
like
in the fence.
That, yeah.
And they fought for 2 years. And the attorney is saying that she owes $9,000, and she alleges it should have been around $1,400. She has until Friday to respond to the attorney, and they won't accept her dues unless she paid the fine. So The lesson here is HOA companies suck. So just miserable entities, and they're crooked. And the shtick here is they have some technical violation, and then the HOA attorneys just charge all of these legal fees, and they don't want to let you just pay the outstanding balance. In order to cure it, you've got to pay all the legal fees, right? Because the HOA attorneys have to be paid.
Yeah, the legal fees are great too. If you ever get a hold of those timesheets of the attorneys for the HOAs, like every single month on like the 15th or something, they'll bill like a file review that took them 2 hours apparently. I don't really think that did, but sure.
We love to get into knockdown, drag out fights with HOA attorneys about how unreasonable their fees are. The problem is the client's paying us to do that, and then that increases their legal fees. All right, enough complaining about HOAs. The specific problem, she built a patio. It was never approved. All right, that kind of is a problem. If you got a patio, the HOA has an approval process. It was never approved. You should be able to try to retroactively get that approved. Hopefully it is not a very hard process. It could be, which would be a problem.
Phil, I don't know if you remember one of the first cases I took here at the firm, an HOA tried to go after our clients for a pool that they had built. Tried to get them to, they had given approval and they tried to revoke the approval and tried to get them to tear down their pool.
Or HOA horror stories.
Yeah.
So the HOA base is, the fees were $1,400. They're trying to get $9,000, allegedly over a picket and a patio. Outright extortion. If I were talking to this potential client on the phone, I'd probably say, you can't beat City Hall and you can't beat HOAs. It's really hard. If we were to file a lawsuit against this HOA, it'd be a $5,000 litigation retainer, and we would probably spend another $5,000 to $10,000 in legal fees trying to get their legal fees deemed unreasonable. And I think we've got a good shot at that, but the client can't really win.
Yeah.
And they're not going to settle it. It's outright extortion.
Yeah.
So normally we just tell these potential clients to go ahead and pay it. You can't beat them. It's a really hard pill to swallow. Yeah. We have had some clients say, just out of principle, I want to fight them, and they pay us to fight them. And that usually ends up being very painful for the client because they're paying us legal fees. So real problem. All right. How about our next question, Austin? What's that?
Someone wants to add their parents to a deed.
Okay. Yeah. And also discuss a transfer on death deed is what's in there.
Yes.
People usually call us to add their parents to a deed because they want to save money on property tax.
Yeah.
And the parents are usually over 65 or whatever the cutoff is to get the lower property taxes. We have to tell them that usually that doesn't work out how they think it will, because when you just add parents to a deed,
you don't automatically get that. Yeah.
It's implied that the parent now owns 50%. So 50% is better than nothing, but the appraisal district is only going to give them a 50% exemption for that over 65 exemption.
Yeah.
So if that's your real goal and it's usually tax driven, then what you want to do is, yes, go ahead and deed the property over to your parents, and they're going to get the entire tax exemption. You can live there, and then your parents would then sign a transfer on death deed back to you. So when they died, the property automatically transfers outside of probate and is back in your name.
Yep.
You have to really trust your parents to do this, right? Because those transfer on death deeds are typically revocable deeds.
Yeah.
So not a bad strategy, but it's one that requires a huge amount of trust with your parents. So
yes, that is correct.
How about the next? What's the next email we got into our inbox here?
The next email is, I trust this email finds you well. First,
always a bad sign. That's always a bad sign.
My team has reviewed the pricing for GreaterHoustonLawyer.com. I guarantee you this person has no team. Probably like it's just this person. It now goes for $499. For an easy payment guide, kindly reply, quote, I am interested. I await your response soon. Also, kindly. If the email says kindly, no, I am never responding to that email. So
our law firm and many lawyers get about 100 of these types of emails a month, and they're trying to sell domains over to attorneys. It used to be, you may know the history about this, Austin. When the internet went public, and I'm going to go way back. The internet went public in 1993. Okay. Between 1993 and Google, there were a whole bunch of search engines. All right. Alta Vista, Yahoo, AOL. But even after Google became popular, you have all these SEO factors, right? Search engine optimization factors. And one of the biggest, and it's an algorithm. And this algorithm is supposed to dictate where your website gets put in the search results. And a huge weight in the logarithm very early on in the history of search engines were exact name domain name matches, right? This is a domain name, GreaterHoustonLawyer.com. And the idea, if this were still, I don't know, 2003 or 2000 or something like that, or 2005, I don't know. The idea would be, if someone were searching in Google or another search engine, Greater Houston Lawyer, and I think that really doesn't make sense. It'd be Greater Houston Area. Greater Houston Area Lawyer would probably be a better domain name. But that just doesn't work anymore. But if it were 2005 or 2004, because you've got an exact match domain name, you're likely to rank very highly. So these people are still selling this to lawyers. I don't know if anyone ever buys this or not, but we get 100 of these a month. We don't ever respond.
No, I do sometimes.
You do sometimes.
I do sometimes to mess with them. Yeah, I like it how almost all of them, their signature is like Bob or Stan or Kevin. I know your name isn't Bob, Stan, or Kevin. Okay.
Do you know there was some dispute or some debate with the state bar? If you were the Silberman law firm, okay, could you have a domain name that was GreaterHoustonLawyer.com? That was a debate for a while.
Interesting.
Because before we allowed lawyers to operate under trade names, lawyers were getting these exact match domain names. And the idea, the state bar at one time may have taken the position, or there was some sort of debate, that by getting a domain name that is GreaterHoustonLawyer.com and not having a domain name like SilbermanLawFirm.com, you're a lawyer operating as a trade name, under a trade name, and therefore you're violating that state bar rule.
Interesting.
And that was the lawyers. We won on that. It was determined that you could, in fact, have a domain name that was not your firm name.
You can do that and call yourself a doctor. Yeah, it's great.
Yeah. Austin's referencing our previous show where lawyers are allowed.
That's DrDFW.com. Austin Black.
Lawyers are allowed to call themselves doctors as long as it's not false or misleading. So from now on, when we start a podcast, I'm going to say, how are you doing today, Dr. Black?
Thank you, Dr. Silberman.
Yeah. Okay, we never buy those domain names. They're worth almost nothing now because in the modern day, the logarithms do not weight exact match domain names very highly for search results. So we never respond.
Got it.
What's our next email?
Sued by HOA for unpaid fees. Answer due Monday. You want me to take this one?
Sure.
Okay. So first off, your answer is due a certain amount of days plus the next Monday of when you are served with a lawsuit. Okay.
Yeah.
So if the answer is due on Monday, they're served around 20 days earlier from that time period. Okay. Now, most of our clients, when they come to us with this, they are potential clients. They think that the process is like if they don't answer on Monday, they instantly have a default taken against them and they're just gone. Like they've lost their entire lives. Someone's going to come raise down their house. Yeah, no, that's not going to happen. Okay. It takes a little bit longer for the default process to move forward. Not saying you shouldn't go ahead and get your answer in by the time it's due. You definitely should. And we do for every case that we work on. But if for some reason you find out about it later or you forgot and you come and it's say 2 weeks past that date, very likely that a default hasn't been taken against you and you're fine to retain counsel to file an answer at that point.
That's right. So we do get a lot of emails on the Friday before the answer's due saying the answer's due Monday. And it would be nice to have some time before the answer's due to digest the lawsuit. There are some things that you can't ever get back when you file your answer. A lot of people think, just file the general denial. It's easy. And a lot of times that is true, but you do need to take a look at the pleading and the petition that's being served against your client and say, at least ask yourself, does the state of Texas have jurisdiction?
Yeah.
Because you can't, once you make an appearance and you don't argue jurisdiction, you can't ever get that back.
Yeah.
So also venue, you can never get venue back. Yeah. And then arbitration, sometimes you have an arbitration clause and you're being sued in violation of your arbitration clause. That one is much more loosey-goosey. Yeah. You can get, even despite being sued, you can ask for arbitration very late. I think the standard, as long as you have not availed yourself of the discovery process.
Yeah.
And there's a lot of sort of cases on what that means and how engaging in the discovery process may at some point forfeit your right to demand arbitration if it's what you agreed to in the contract. But the merits of this question is really how I was sued by the HOA for unpaid fees. Yeah. In these cases, you don't want to let the HOA necessarily write a blank check.
Yep.
So we will recommend, let's answer the lawsuit, but let's not fight them too much because you can't win. If you haven't paid the fees, they need to be paid. Yeah. Let's answer the lawsuit, get the fees paid. I don't really trust the HOA to, even if you just blindly pay the HOA, I don't trust the HOA to not take a default judgment. And or if you just pay them like they're going to non-suit it, I just don't trust them to do that. So I say, let's answer the lawsuit. Let's work it out. Let's do a settlement agreement. Let's get them paid, but be sure that lawsuit gets closed out properly. Yeah. This next one on our inbox. What is this one?
I am currently out of office and will be returning on Monday, December 2nd, 2024.
Yeah, that's a triple O.
Oh, yeah.
Out of office. Do you use out of office responders? Automatic response? I don't.
I do sometimes. Really, the only time I use them is if I'm actually in some place that I know has issues with internet access. And that's very rare nowadays, right? But that's the only time I really use them. Otherwise, if I'm going somewhere, I let my clients know that I might be on a different time zone, something like that, or more easily accessible via email, but I let them know.
So here's what I think is super ridiculous about this. All right. You ever see those, what Austin's talking about, okay, you email an attorney or an executive or something like that, and they're on vacation. Yeah. And you get the automatic out of office response. And it says something to I'll be out of the office until Monday, December 2nd, 2024. During this time, I have very limited access to email, right? That's not true.
No.
It's nobody has.
There are some very limited situations where it's true, but usually yes.
Yeah. If you're in jail.
If you're in jail, or say, for instance, I have some friends who are going to Nepal for the holidays and they're going to be hiking. They actually will have limited access to internet there. So,
yeah. It's usually not the case. Yeah. I want to see someone put something like really honest in their out of office. I think somebody did this. I think there was a Wall Street Journal article on it where people started to be blatantly honest in their out of office auto responses. And it's something like, I am out of the office. I am taking a real vacation for 1 week. Do not bother me unless it's a bona fide emergency.
Yeah.
Here's a list of things that are not emergencies, right?
Yeah.
So anyway,
Yeah.
all right. We knocked that one out. What's the next one, Austin?
I wanted to follow up on my proposal regarding the AI attorney and law mobile app development.
Whoa, just stop there. Okay. Everything is AI now. He's just throwing this is someone.
This is just a bunch of buzzwords altogether. Yes.
Someone is not probably in the United States, most likely in India or the Philippines or somewhere. And my proposal regarding the AI attorney and law mobile app.
The AI attorney and law mobile app.
It's everything.
Not an AI attorney and law mobile app, like one that I'll make for you, because that's what it is. He's saying that he'll make an app for our firm.
I can't figure out what he's saying. It does everything.
It can do absolutely everything. Yes, it can.
Court hearing tracker.
Yes.
Video conferencing as opposed to Zoom or Google Meet, right? He's got the app that's better than Zoom or Google Meet. Data encryption and security. This guy's he
does everything. He's a security contractor.
E-signature functionality like DocuSign.
Nice.
Billing and payment integration. He's also selling like Clio.
This guy just made Clio. He made Clio. He makes Clio repeatedly. Yes, this is
legal chatbot. Yeah. AI powered. He's got something better than ChatGPT.
Yeah, I'm sure.
Secure document sharing. That's something better than Google Drive. Appointment scheduling. It's everything. Client portal. May I send you app portfolio and prices?
I don't know what he wants to send me. Actually, I don't know, because there's no comma between app. Is there a portfolio of apps that he's completed and the prices for them? Is he actually going to just send me an app? I really don't know.
I'm going to use this opportunity. Okay, we've made fun of it enough, but I'm going to use, I've mentioned what we do at our firm. I'm going to use this opportunity to give my 2 cents on this stuff. Court hearing tracker. You just calendar your hearing, whatever calendar you're using, right? Google Calendar.
I will say it is a little bit difficult with a lot of cases to make sure you're tracking everything. You get a notice of a hearing, sometimes get buried or something like that. It can be difficult.
If I think most attorneys, if you're not running like a car accident docket and you have 20 litigation files, I think you as the attorney, you get a hearing and you calendar it, whatever calendar you use. There are a lot of law firms out there that will have a secretary or a paralegal calendar it. I think calendaring all of your deadlines in your docket control order or a discovery plan or something like that under the Texas Rules of Civil Procedure. I think that kind of calendaring can clutter up your calendar, but hey, it's hard being a lawyer. You got to keep track of your dates.
And I think that's what I'm talking about. Hearings are easy. You get a notice hearing. Okay, yes, put that on there, no problem. But yeah, like all the different docket control orders and everything. I go to one day, I have 20 different things showing up on there, and they're all related to different docket control orders. Yeah.
All right. Video conferencing, we use Google Meet. The courts are still using Zoom predominantly, right?
Yeah, I had one court using Microsoft Teams, and I never was in that court again, but yes.
Yeah. Data encryption and security. This stuff, most small law firms do not have some sophisticated data encryption and security system. It's not like Amazon gets like 1 billion attacks and threats a day or something like that.
Yeah.
You need to have some security. Stuff needs to be password protected. Usually the software you're using, you're going to rely on their data encryption. So if we use Clio, for example, Clio, I hope, which is a gigantic law practice management software, they're going to have some data encryption on their side.
Yeah.
E-signature functionality, we use DocuSign. Billing and payment integration, that's done through Clio. Most that's a huge law practice management software out there.
Yeah.
Probably the most popular one. We do take credit cards. A lot of firms out there will take credit cards now, and typically you're using some sort of merchant services provider. If you take a lot of credit cards like our firm does, you're going to be able to get wholesale rates.
Yeah.
Legal chatbot. we use Chat GPT. Austin, I know you programmed a chatbot, a GPT, right? So I use them all the time. I have a legal assistant GPT that's based on all of my articles that I've written, all of our intake guide that we use.
Don't let it write pleadings for you without verifying everything in there, though. When we talked about the New York attorney that got sanctioned this week, there was a Texas attorney that got sanctioned for the same thing. So
it will hallucinate stuff.
Yeah.
Okay. Secure document sharing. We use Google Drive for that. I guess Google's pretty secure. If Google's not secure, I'm in trouble. But yeah. That's what we do. We don't need these services, I'm afraid. Okay, so next one.
I hope this message finds you well. Again, it didn't. I noticed you haven't renewed your Martindale NOLO lead generation program in some time.
Okay, all right. So that you may not know about this, but Austin, if you're a firm owner like I am, you get a bunch of these. They sell you lead. If you don't have enough work, like they'll sell you potential new client leads.
Yeah.
And I think there's some proposed state bar rules that are coming out to try to regulate this a little more. We don't buy leads, but if you're a lawyer out there, that's something, and you're a little slow, you can buy.
Your business is a little slow, to be clear. This is not talking about you personally being. This can't help you with that.
You may be both, but
that might be why business.
You can pay for like legal leads, maybe for $50, $100 a lead. And they may not be exclusive. You should ask the question, are these exclusive leads, right? Are they only contacting me, or are they selling them multiple times to multiple lawyers and you're competing for them? I don't think it's a great way to do business and get business. I don't love the idea, but these companies out there, they do it, okay? Next question, Mr. Black.
A construction company who built a small community for a developer, and the developer was sued, is now the construction company is now being dragged into this lawsuit by the developer who was sued. So he received a motion for an interlocutory default judgment. Okay, so if he's getting an interlocutory default judgment, this is past the point of him getting dragged into it.
He's confused. What's going on here, it looks like, is if you have a parcel of real estate, there'll be a developer. The developer is responsible for putting the whole project together. That developer will hire a builder. The builder, in this case, built a residential home. And then the developer sells the lot and the improvement that was built to an end user, who in this case is the home buyer. Home buyer lives in the home, doesn't like it, thinks there's problems with it. The home buyer sues the developer. That's the person he had a contract with that sold it to him, and the builder. That's what's going on. So
that never happens, though. People never move into a home and have problems with it. That is roses and peaches. Yeah.
I mean, I will point out that in this case, the builder doesn't have privity of contract with the end user, the buyer.
The buyer. Yeah.
So the buyer probably doesn't get a right to sue him for breach of contract, but the builder may have transferred some warranties to the buyer, and the builder certainly owes contractual obligations to the developer. So ultimately, if the home buyer sues, the developer is going to turn around and sue the builder. So the builder's in this deal anyway. Motion for interlocutory default judgment, I think he just means he didn't file an answer yet, and now the other side has filed a motion for default. Yeah. That's what I think.
Yeah, he file an answer.
Yeah, if you file an answer, that's going to make the motion for default moot. Okay. Yeah. So what's our next question, Mr. Black?
I hope this message finds you well. For the third time, it has not, and it will not. I'm blank, talent delivery manager at blank company. I'm reaching out regarding the associate attorney position in Houston, Texas. We have identified several qualified candidates in our database who may be a great fit.
All right. So what we have here, it's a recruiter email. When we routinely have job postings out for associates, when we do that, they look at the postings, and our recruiters solicit us, right?
Yes.
We don't use recruiters. Some firms do. I don't love using recruiters, and here's why. This one happens to be offering a 15% fee. So basically, if you hire an attorney for $100,000, you have to immediately pay $15,000 up front.
Yeah.
And Austin, I'm going to tell you, in this labor market with millennials and Gen Z, that's a really bad deal, because millennials and Gen Z have an average turnover of about 2 years.
Yeah.
So you're paying 15 grand. And then the guy says he's got a 90-day replacement warranty.
Yeah.
It's not a good deal to pay 15 grand for associate talent and then have them leave and only get a 90-day warranty.
I've never seen a recruiter offer a year guarantee.
No, so they're terrible. And you got to pay these guys all up front 15 days from the start date. That's what this one wants. Yep. And the normal fee, by the way, is 25%.
Wow. So
this guy's cheap. I don't love headhunters. I don't love recruiters. I think it's a bad deal. I don't know why you just wouldn't you can run a job ad on Indeed for $500 or LinkedIn. For this post, I just ran LinkedIn and Indeed for $250 each. And I had a senior associate position and I had a regular associate position. I had 20 qualified resumes for each job post. Yeah. So now, if I'd done that 2 or 3 years ago, it'd have been less. The labor market for attorneys anyway has severely softened. And it's always like an ebb and flow kind of thing. Yeah. But hey, that brings our show to a close. That was our last question.
Okay.
That was rapid fire potluck. If you're going over to family and you're doing a little potluck for Thanksgiving this year, you don't know what you're going to get, right?
That's true. You could get someone selling you medical equipment and construction equipment. That could happen too. Yeah.
Yeah, but hopefully, I guess it could happen at Thanksgiving dinner. But
yeah, that would be really awkward. Yeah, I wouldn't like that. I'd prefer politics discussion over that. So yeah.
All right, that brings our show to a close. My name is Phil Silberman. Austin Black has been my very valuable and capable co-host, who I am extremely thankful for. As a reminder, nothing in this show is meant to be legal advice. It's all been for entertainment purposes only. If you have a question, feel free to email us at info@silblawfirm.com. Tell us you want us to answer it in the podcast. We will do our best. Everybody have a great Thanksgiving.
Yep. Happy Thanksgiving.